Good morning. Today is the first day of September 2009, and welcome back to my program. My name is James Stratton, and I help people through some of the toughest times in their life through a process called mediation. I help take the very complicated and make it very simple. Part of my job is to help restore relationships and reputations in a confidential setting, unlike what you will find in the courthouse. Well, if you were with our program yesterday, we got to talk about a case in which there was a home builder who had run into some trouble with a home buyer. This was a real estate transaction case and a construction case. So today we will go over the plaintiff's position in their case, and then tomorrow we will go over the defendant's position in their case. On Thursday, we'll look at the cases and see how mediation could have helped out in this situation if applied in a proper manner. And we'll go over all the tactics that were used in court during the 2-year period that this case was pending. And I don't know if you caught that, but that was a 2-year period in which this case was pending. All right, well, let's get into it. Here we go. In this particular case, the court filings are gotten right off the Tarrant County courthouse pages. And the filing is a 15-page petition in which they're complaining of the defendant. Now, here comes the surprise. As we discussed earlier, there was some problems with a water leak inside the house, and it would seem pretty straightforward on its face value that maybe the home buyer would be the one suing the home builder, but not in this case. In this particular case, the home builder is suing the home buyer, and like I said, they filed a 15-page petition in court complaining of several different things of the home buyer. So let's get into some of the facts here real quick. You have to forgive me while I get my glasses on. There we go, right? There we are. In or about August 2003, the defendants entered into an agreement to purchase a certain custom home then in the process of being built by the plaintiff, which is located in Westlake, Texas. A true and correct copy of the home purchase contract is attached. Once under contract, defendants, that was the home buyers, had significant input into the finish out and details of the said home. Construction of the home was completed in January of 2004, and the defendants closed on the purchase of said home on or about January 28, 2004. Thereafter, defendants moved into the home on February 1st, 2004, and took up their primary residence at said home. During the construction of said home, defendants were presented with the option of including certain features, including a water filtration softener system. In order to save money, defendants elected not to purchase this feature, and the home was constructed without a water filter softening system. Remember, I told you yesterday that custom home builders typically have craftsmen that work for them. And they're more project managers than actual home builders. But they have craftsmen they like to go to, and that's the reason why they're complaining of this in here. Thereafter, about February 2004, unbeknownst to the plaintiff, defendants installed an underground reverse osmosis water softening system at the home. Wow, okay, so now they've decided not to use the builder's water softening system, but instead have gone to a third party and purchased one. Okay? In or about March of 2004, defendant began complaining to plaintiff of water leaks at the home, beginning with a water leak in the wine cellar located below ground level under the stairs and on the first floor of the home. Upon receiving said complaints from defendant, plaintiff immediately took remedial action, including inspections, evaluations, and retaining the services of a sealant company to seal the walls of the wine cellar. The sealant seemed to correct the water leakage for a period of time, but over the course of the next 6 months, defendant continued to complain of water seepage in various locations in the home, including the wine cellar, the master bedroom closet, and the master bathroom in the dining room. During those 6 months, plaintiff spent approximately $50,000 attempting to locate the source of said water problems, correct the water seepage in the home, and repair the resulting damage. Specifically, the plaintiff sealed several areas of the brick on the home, paid a company $9,500 to conduct a mold remediation and air quality testing, removed sections of the wall and replaced the same, installed a drain in the master bathroom floor, installed a French drain outside the home near the master bedroom and master closet, and repaired the land grading on the exterior of the home that the defendants had previously disturbed during their landscaping efforts. Okay. All right. Now, during the time plaintiff, who knew there had been no water leakage or seepage problems during the year the home was being built, and who knew the home had passed all required inspections, was perplexed as to the sudden water issues at the home. So in other words, the home builders wonder what's going on. It passed all its inspections. All right, so here we go. Just to cut to the chase on this, what are they actually looking for? All right, their causes of action are several. They have a cause of action of quantum merit. They have another cause of action of fraud, negligent misrepresentation, defamation and business disparagement, torturous interference with business relationships and opportunities. That's interesting. Negligence, conversion and civil theft, theft of services, and declaratory judgment. Okay, so what do they want? Well, first of all, they're claiming that the plaintiff has sustained a loss of goodwill, loss of payments for services, loss of present and future business opportunities, lost profits, and reputational injury to the plaintiff. Okay, so they're not only wanting damages for that, but now they want exemplary damages because these people they feel like they did it on purpose. Plus attorney's costs and court costs. And they're asking for a jury trial. All right, so pretty straightforward on that. Now, the burden is on the plaintiff to be able to prove all these cases up. So tomorrow, when we go look at this case, we're going to discuss the defendant's position on the case. Theirs is rather simple, so we'll spend time actually explaining what the defendant will have to do in order to defeat the elements of each one of these causes of action. Now, then on Thursday, like I said, we'll discuss the case as to how mediation could have helped both prior to litigation and during litigation had it been incurred at that point. All right, well, now if you found yourself in a similarly situated situation, did I say that right? If you have found yourself in a similar situation, please feel free to contact me through my blog at whoisjamesstratton.com/blog1. Or if it's more of a private situation that you would like to discuss, you can contact me through my email at james.stratton@interventionmediation.com. Sorry to keep the program short. Remember, we have a 10-minute time limit, and we kind of do this without a script, so there's no telling how long it takes us to do it. I will see you tomorrow, and have a great day.